Good evening, officers from the states of Punjab, Haryana, and Chandigarh. We are extremely sorry for the delay as there was some technical issue. In pursuance of instructions of Honorable High Court, this webinar has been organized by Chandigarh Judicial Academy to sensitize officers regarding the guidelines for recording evidence of vulnerable witnesses as adopted by our Honorable High Court. With this regard, an earlier webinar was also organized in which some provisions of the guidelines have been discussed, and the remaining provisions we will be discussing today in this webinar. If any officer has any query, he or she may write in the window that will be answered today after completion of the guidelines, or the officer may send an email on the address of Chandigarh Judicial Academy and the same shall be answered. Now I request Shri Amit Kumar Sharma ji to please enlighten the officers regarding the guidelines.
Thank you, Monika. A very good evening to all the officers. In the last webinar, we covered up to clause 13, which was regarding legal assistance and legal aid. Now we will proceed further. Clause 14 says, court to allow presence of support persons. As you might be aware, the definition of support person has been provided in clause 3, subclause B. The court shall inform vulnerable witnesses that they may take the assistance of support person during the trial. In cases under POCSO Act, the concerned court shall take into consideration the role of support persons as provided in POCSO Rules 2020. The court shall allow suo motu or on request the presence of a support person of the choice of vulnerable witness in courtroom during deposition, provided that such support person shall not completely obscure the witness from the view of the accused or the judge. The court may allow support person to take appropriate steps to provide emotional support to vulnerable witnesses in the course of proceedings, and also inform the court if the vulnerable witness needs break or is feeling stress or triggered. The court shall instruct the support person not to prompt, influence, or tutor the vulnerable witness during their testimony. Where no other suitable person is available, the court should appoint the support person being guardian or parent. The court shall ordinarily appoint a neutral person as a support person. It is only in exceptional circumstances, keeping in view the condition of vulnerable witness in mind, that the court should appoint a parent as a support person. The court shall allow support person to coordinate with the stakeholders such as police, a special juvenile police unit, medical officer, prosecutors, mental health professional, child welfare committee, juvenile justice board, defense counsel, and courts. As far as possible, the concerned court shall ensure the continuity of the same support person during the deposition. If the support person is also a witness, then it is the duty of the court to ensure that his or her testimony is recorded ahead of testimony of vulnerable witness. Over to Monika ji.
Thank you, sir. There is further guideline with regards to right to be informed. It provides that a vulnerable witness, their parents or guardians, they have a right to be informed about certain things, and they should be informed by the court about the stage of process and to the extent feasible and appropriate about these things, which include the charges which have been brought against the accused, the progress of the court, the procedure of the criminal justice system, including the role of the vulnerable witness, the existing support mechanism for the vulnerable witness, the schedule of the court proceedings that vulnerable witness is either required to attend or is entitled to attend. They further have a right to be informed about right of the informant or person authorized by the informant to be present at the time of hearing of bail applications under section 65 subsection 1, 65 subsection 2 and 70 of Bharatiya Nyaya Sanhita, all under POCSO Act. They also have a right to be informed about the victims, right of the vulnerable victims and their dependents to be heard during the proceedings of bail, discharge, release, parole, conviction, sentence of an accused. Further, availability of public and private emergency. They have a right to be informed about availability of protective measures, availability of victim compensation benefits, availability of the legal aid rights, availability of institutional and non-institutional care under the juvenile justice system. They further have a right to be informed about all the decisions, at least those decisions affecting the interest of victim or vulnerable witnesses, and the process of appeal against the order of the court. Over to Shri Amit Kumar Sharma ji.
Thank you, Monika ji. The last webinar of this series was held on 31st October, but till date, we have not received a single query. This shows that either you have understood the entire process, and if it is so, there should be increase in recording statement of vulnerable witnesses. Now I proceed further. Clause 16, which speaks about waiting area for vulnerable witness. The court shall ensure that a waiting area for vulnerable witnesses with the support person and the lawyer of the vulnerable witness, if any, is separate from waiting area used by other persons. Care should be taken to ensure that the waiting room is used only by vulnerable witness and the non-offending family members and support persons. The waiting area should be accessible to all vulnerable witnesses, including those with disability. The waiting area for vulnerable witness should be furnished so as to make a vulnerable witness comfortable. This may include painting material, other activities, TV, which can help lower anxiety of such witnesses. It could include a space for every young child witness to rest or sleep. Accessible toilets and drinking water facilities should also be available inside the waiting room or within close proximity. The approach to the waiting area shall be in such a way that allows the witness to access with ease and without having to confront other litigants, police, the accused, and their associates. The waiting area needs to be equipped with a digital case number display monitor that shows that the case being called in the court. It is the duty of the court to make arrangement for vulnerable witness to depose from the waiting area, which may include monitors and screens for recording of the evidence of the child shall be also made available. Over to Monika ji.
Thank you, sir. Further, the guidelines provide for the duty to provide comfortable environment. So it provides that it shall be duty of the court to ensure that a comfortable environment for the vulnerable witness by issuing directions and also by supervising the location, movement, and deportment of all the person in the courtroom, including the parties, their counsels, vulnerable witnesses, support persons, etc. It further provides that safe and separate waiting areas and passage should be provided for the vulnerable witnesses. Care should be taken to ensure that vulnerable witness courtroom is accessible to persons with disabilities also. The vulnerable witness may also be allowed to testify from a place other than the witness chair if the circumstances demands so. In case of a victim of sexual offense, care should be taken to avoid the exposure of the accused at the time of recording of evidence to the victim, while ensuring the right of cross-examination of the accused and that the accused is in a position to hear the statement of the child and communicate with their advocates. While deciding to make available such an environment, a judge may also dispense with wearing their judicial robes. Over to Shri Amit Kumar Sharma ji.
Thank you. Up to clause 17, as you have noticed, that composition, particularly the structure of deposition center, has to be dealt with. Now I come to duty of judges of criminal courts, children courts, or juvenile justice board. Vulnerable witness shall receive high priority and shall be dealt as expeditiously as possible, minimizing unnecessary delays and adjournments to avoid repeated appearance of the witness in the court. Judges and court administrators should ensure that developmental needs of vulnerable witnesses are identified, recognized, and accommodated in the arrangement of the courtroom and recording of the testimony. For example, judges should use developmentally appropriate language, schedule hearing for the record of testimony, bearing in mind the attention span, physical needs, and exam schedule of young vulnerable witnesses, and allow use of testimonial aids as well as translators as and when necessary. The judges should ensure that vulnerable witnesses with disability are able to exercise their right to access the court without any discrimination on the basis of disabilities. In case of a victim under section 74, 75, 76, 62, 66, 67, etc., where the victim is permanently or temporarily mentally or physically disabled, their statement under section 183 shall be considered as a statement in lieu of examination in chief. In short, a statement of witness given under section 183 or section 164 CRPC be considered as her statement in lieu of her examination in chief. Additional measures may be taken to enable the recording of evidence of vulnerable witnesses with disability. For instance, steps can be taken to record witness testimony in compliance with section 313 BNSS in Braille to ensure a vulnerable witness is not dependent on another person to read their testimony. Use of amplification, document magnifiers, etc. must be available by accessible means and accessible formats so that the witness can freely use the same. The court should be satisfied that a victim or vulnerable witness is not scared and that they are able to reveal what happened to them when they are subjected to examination during recording of the evidence. The court must ensure that the victim is not concealing portion of evidence for the reason that they were ashamed of what happened to them. The court shall ensure that adequate time and opportunity is given to refresh their memory. In cases of sexual offenses, the judges should avoid asking vulnerable witness to demonstrate intimate touching on their own body during recording of the testimony, and the witnesses can instead be asked to point to a body outline diagram. Judges should be flexible in allowing the witnesses to have a support person while testifying and should guard against unnecessary securitization of support persons or any other person permitted to be present during testimony of such witnesses. Judges should encourage the victim to let the court know if they have any problem, do not understand a question, or if they may need a break. Judges should ensure that steps are taken to ensure the atmosphere is comfortable and not intimidating. For instance, the court may consider allowing a limited number of defense lawyers to be present in the courtroom during deposition of such witnesses. Judges shall carefully monitor the examination as well as cross-examination of the victim to avoid any harassment or intimidation to the victim. Judges may allow a witness to carry a comfort item during the deposition. Judges may provide transport or transportation cost for the witnesses in accordance with the guidelines prescribed by Honorable High Court in this regard. Judges shall ensure that the requisite guidelines and SOP affirmed by Honorable Supreme Court in respect of recording of evidence of vulnerable witnesses is followed. Now, I request Monika ji to read further.
Thank you, sir. Further, the guidelines provide for allowing the proceedings to be conducted in camera. The mandatory requirement of in-camera trials, as is provided under Section 366 of BNSS and Section 37 of POCSO Act, shall be ensured and recorded in the orders passed in such cases. The guidelines provide that in all other cases, the court may, at the time of the testimony of vulnerable witness, order in writing the exclusion from the courtroom of all persons who do not have a direct interest in the case, including the members of the press. The guideline further provide that in making such order, the court shall consider the developmental level of the vulnerable child witness, the nature of the crime, the nature of the testimony, etc. Over to Amit Kumar Sharma ji.
Thank you, Monika ji. Most of the guidelines pertains to civil or criminal cases both, but clause 20 specifically deals with guidelines while recording a statement of vulnerable witnesses in criminal cases. It says live link television testimony in criminal cases where the vulnerable witness is involved. Any party in the case, the prosecutor or guardian may apply for an order that testimony of such witnesses be taken in a room outside the courtroom and be televised to the courtroom by live link television. In order to take a decision qua usage of live link, the judge may question the witnesses in chambers or in some comfortable place other than courtroom, in the presence of support person, guardian, prosecutor, and counsel for the parties. The questions of the judge shall not be related to the issues at trial, but to the feelings of vulnerable witness about testifying in the courtroom. The court, on its own motion, if deemed proper, may pass orders in terms of any other suitable direction for recording the evidence of such witnesses. Over to Monika.
The next provision is regarding provision of testimonial aids to prevent exposure of vulnerable witness to the accused. In this guideline, the court may either suo motu or on the application made even by the vulnerable witness, prosecutor, or counsel or guardian order testimonial aids such as screen, one-way mirror, curtains, or any other devices to be placed in the courtroom in such a manner that vulnerable witness cannot see the accused or the opposite party while testifying, and at the same time ensuring that the opposite party accused is in a position to hear the statement of the vulnerable witness and communicate with the advocate. The court shall issue an order in writing stating the reasons and describing the approved courtroom arrangement in the judgment also. Over to Amit Kumar Sharma ji.
Thank you, madam. Now I come to clause 22, which deals with factors to be considered while considering the application under guidelines. The court may order that testimony of a vulnerable witness be taken by live link television if there is a substantial likelihood that the vulnerable witness would not provide a full and candid account of the evidence if required to testify in the presence of accused opposite party, their counsel, or the prosecutor, as the case may be, or if the witness is likely to be traumatized by exposure to the accused. The order granting or denying the use of live link television shall consider the following reasons: the age and level of development of vulnerable witness, the physical and mental health, any physical, emotional, or psychological harm related to the case, on the trauma experienced by such witnesses, the nature of alleged offense and circumstances of its commission, any threat against the witness, the relationship of the vulnerable witness with the accused or adverse party, the reaction of the vulnerable witness to any prior encounters with the accused in court or elsewhere, the reaction of witness prior to trial when the topic of testifying was discussed by parents or professionals, a specific symptom of stress exhibited by witness in days prior to testifying, testimony of expert or lay witnesses, the custodial situation of the child and the attitude of the members of child's family regarding the events about which the child will testify, the wishes of the vulnerable witness on the manner in which they would like to render the testimony, and any other relevant factor as the court atmosphere and formalities of court procedure. The court shall ensure ahead of time the equipment is working, recording can be played, and the camera angles will not permit witness to see the defendant. The court shall not wait until the victim or vulnerable witness is in the live link to run checks. Delays and malfunctions can be disruptive to such witnesses. Where a live link is being used during vulnerable witness testimony, ensure that they are able to see all the questioner's face. It should be explained that the judge or magistrate can always see the witness over the live link video, even when the witness can't see the judge or the magistrate. Now over to Monika ji.
Thank you, sir. The next guideline is with regard to mode of questioning. This guideline is somewhat similar to the POXO rules. The guidelines as provided says to facilitate the ascertainment of truth, the court shall exercise control over the questioning of vulnerable witness, and the court may do so by ensuring that court questions are kept simple and stated in a form appropriate to the comprehension and developmental level of the vulnerable witness. Protecting vulnerable witness from harassment or undue embarrassment, character assassination, aggressive questioning, and ensuring that the dignity of such witness is maintained at all the times during the trial. Avoiding waste of time by declining questions which the court considers unacceptable due to their being improper, unfair, misleading, needless, unconnected to the case, allowing the vulnerable witness to testify in a narrative form. In cases involving multiple accused persons or defendants, the court may take steps to minimize the repetition of questions, and court may require the counsel for different parties to provide questions in advance from all the counsels. In cases involving sexual offences against child victims, the courts should ensure that questions are put to child victim only through the court. The guideline further provides that the objections to questions should be couched in such a manner so as not to mislead, confuse, or frighten the vulnerable witness. The court should allow the questions to be put in simple language, avoiding any slang. The court should ascertain the spoken language of the victim or vulnerable witness and range of their vocabulary before recording the evidence. The court must not allow the questions carrying words capable of multiple meanings, questions having use of both past and present in one sentence, or multiple questions which are likely to confuse such a witness. Given the developmental level of the vulnerable witness, excessively long questions shall be required to be rephrased and thereafter put to the witness. Questions framed as compound or complex sentence structure or two-part questions or those containing double negatives must also be rephrased so that the witness is able to understand the same. Over to Shri Amit Kumar Sharma ji.
Thank you, Monika ji. The next clause is clause 24, which provides rules of deposition to be explained to the witnesses. The court shall explain to a vulnerable witness the rules meticulously and carefully. It is the duty of the court to explain to the witness, to listen to the questions posed, and to tell the court the true version of events as far as possible, except in the case of very young children, not to respond by shaking their head to means yes or no when answering. To specifically state if the witness does not remember or has forgotten something. To clearly ask when the question is not understood. A gesture by a vulnerable witness to explain what had happened shall be appropriately interpreted and recorded in vulnerable witness deposition. Assistance of an interpreter or special educator shall be taken if the witness is unable to communicate verbally, and such a statement should be videographed. Clause 25 speaks of compensation. As you are all aware, that Honorable Supreme Court in a recent case has directed that it is the duty of every judge to guide or pass orders for assessment of compensation. And if for any reason the presiding officer considers that such order is not to be passed, then he or she is to record reasons thereof. Clause 25 incorporates the same, which says the court shall apply its mind to the question of award of compensation in every case involving a victim who is vulnerable witness, having regard to the applicable laws and schemes. Then comes clause 26, protection of privacy and safety. Orders and judgment pertaining to cases involving vulnerable witnesses shall be made available on e-court or on the official portal of the court after identifying information of vulnerable witnesses. Any record containing identifying information regarding a vulnerable witness shall be confidential and kept under seal, except upon written request and order of the court. The record shall only be made available to members of the court staff for administrative use the public prosecutor for the purpose of inspection, defense counsel, the guardian for inspection, other persons as determined by the court. Clause 27 is about protective order. The deposition of a vulnerable witness recorded by video link shall not be video recorded, except under reasoned order requiring special measures by the judge. However, where any video or audio recording of a vulnerable witness is made, it shall be under a protective order which should contain a transcript of the testimony of the vulnerable witness and maintained on record of the case. Copies of such transcript shall be furnished to the parties of the case. Recording may be viewed by the parties, their counsels, their expert witnesses, and the guardian in the office of the court following procedure similar to inspection of document and court files. No person shall be granted access to the recording or any part thereof unless they sign a written affirmation that they have received and read a copy of protective order that they submit to the jurisdiction of the court with respect to protective order, and that in case of any violation thereof, they will be subject to penalties provided under the law. Any recording, if made available to the parties, shall bear the following cautionary notice. The object or document and the contents thereof are subject to a protective order issued by the court in case title, case number. They shall also be examined, inspected, read, viewed, or copied by any person or disclosed to any person except as provided in the protective order. No additional copies of the tape or any of its portions shall be made, given, sold, or shown to any person without prior court order. Any person violating such protective order is subject to contempt power of the court and other penalties prescribed by law. No recording shall be given, loaned, sold, or shown to any person except as ordered by the court. This protective order shall remain in force and effective until further order of the court. Now over to Monika Lamba ji.
Thank you, sir. Coming to the next provision, clause 28, which provides that personal details during evidence which are likely to cause threat to physical safety of the vulnerable witness should be excluded. It provides a vulnerable witness has a right at any court proceedings not to testify regarding the personal identifying informations, which includes their names, address, telephone number, school, or any other information that could endanger their personal safety or that of their family. The court may, however, require the vulnerable witness to testify regarding the personal identifying information in interest of justice. Clause 29 deals with destruction of videotapes and audio tapes. Any video or audio recording of a vulnerable witness produced during the provisions of these guidelines or otherwise made part of court record shall be destroyed as per the rules of Honorable High Court. Over to Shri Amit Kumar Sharma ji.
Thank you, madam. Now we proceed further. Clause 30. It says the protective measures to be adopted while recording a statement of vulnerable witness. At any stage in the justice process where safety of a vulnerable witness is deemed to be risked, depending upon the intensity of the threat perception, the court shall suo motu arrange to have protective measures put in place for the vulnerable witness or refer the matter to the competent authority under the Witness Protection Scheme 2018. Those measures may include prohibiting direct or indirect contact with the witness and the accused at any point in the justice process, restraint orders, direct continuation of bail conditions during trial, protection for a vulnerable witness by the police or other relevant agencies, and safeguarding the whereabouts of the vulnerable witness from disclosure. Any other protective measure that may be deemed proper, including those stipulated under Witness Protection Scheme of 2018, may also be passed by the court. Then come clause 31, which is about review and monitoring. The implementation of the guidelines shall be reviewed annually, and for this purpose, Honorable High Court concerned shall engage independent research bodies or organizations, reputed academic institutions, universities, or constitute a multidisciplinary committee, including experts having experience of working with vulnerable witnesses. The recommendations received shall be promptly acted upon, and the guidelines may also be updated based on relevant legal developments. Over to Monika ji.
Thank you, sir. There are further additional guidelines specific to the child victims and witnesses. Coming to clause 32, which deals with developmentally appropriate questions for child witnesses. This provision provides that the questions asked to assess the competence of a child witness shall be appropriate to the age and developmental level of the child, shall not in any manner be related to the issues at trial, and shall focus on the ability of the child to remember, communicate, distinguish between truth and falsehood, and appreciate the duty to testify truthfully. Further, clause 33 provides for appointment of guardian. The court may appoint any person as a guardian as per law to a vulnerable child witness who is a victim of or a witness to the crime, having regard to the best interests after considering the background of the guardian and their familiarity with judicial process, social service programs, and human development, giving preference to the parents of the child if qualified. The guardian may be a member of bar, practicing advocate, except a person who is himself a witness in any proceedings involving the vulnerable witness. The guidelines further provide for what are the duties of such a guardian, which is provided in clause 34. It says, it shall be duty of the guardian of the vulnerable child witness so appointed by the court to attend all the depositions, hearings, and trial proceedings in which the vulnerable witness participates, make recommendations to the court concerning the best interest of the vulnerable witness, keeping in view the needs of the witness and observing the impact of proceedings on the witness, explain in a language understandable to the vulnerable witness all the legal proceedings, including police investigation, status, progress of the trial, child-friendly measures and rights, and witness protection measures in which vulnerable witness is involved. Further, it is the duty of the guardian to assist the vulnerable witness and their family in coping with the emotional effects of participating in any case or proceedings, especially the crime and subsequent criminal or non-criminal proceedings. Further, to remain with the vulnerable witness while such witness has to wait to testify. Over to Shri Amit Kumar Sharma ji.
Thank you, madam. We are already spilling over the time, and therefore I try to cover up rest of the clauses as quickly as possible. Clause 35, testimony during appropriate hours. The court may order that the testimony of the child witness should be taken during time of the day when the vulnerable witness is well rested and does not clash with their routine activities like meal, sleep timings, attending schools, exams, or other activities specific to that particular witness. Clause 36, frequent breaks during testimony. The child witness may be allowed reasonable periods of relief and breaks while undergoing depositions as often as necessary, depending on their age, disability, and developmental need. Clause 37, measures to protect the privacy and well-being of child witness and witnesses. Confidentiality of vulnerable witnesses and judicial transparency are not mutually exclusive, and the vulnerable victims' right to information and access to court record in their own case shall not be restricted in the name of protecting their privacy and confidentiality. It is possible for the courts to maintain anonymity of witnesses through simple name suppression measures, which would then enable release of court documents without endangering their privacy. Best practices from various countries and international tribunals and courts may be adapted for the purpose of balancing confidentiality and judicial data accessibility and transparency to ensure that the privacy and physical as well as mental well-being of a child victim and to prevent undue stress and secondary victimization. Taking into account the best interest of such witnesses, the court may order one or the following measures to protect the privacy as well as physical and and well-being of the vulnerable child witness. Concealing from public record their name, addresses, workplaces, etc. Next, prohibiting the defense lawyer or persons present in the courtroom from revealing the identity of vulnerable witnesses or disclosing any material information that could lead to identification of such witnesses in the media or the public. Protecting the identity of child victims and permitting disclosure in accordance with relevant statutory provisions and judicial precedents. Assigning a pseudonym or a number to a child victim in cases of sexual offenses, in which case the full name and date of birth of the child shall be revealed to the accused for preparation of their defense. In other cases, a pseudonym may be assigned as per request of the parties. Avoiding exposure to the accused by using screen or single visibility mirror. Holding in-camera trial. If the child victim refuses to give testimony in the presence of the accused, or if circumstances show that the child may be inhibited from speaking freely in that person's presence, the court shall give orders to temporarily remove the accused from the courtroom to an adjacent room with a video link or a one-way mirror visibility into the courtroom. In such cases, the defense lawyer shall remain present in the courtroom and question the witness, and the accused right of confrontation shall be guaranteed. Last, taking any other measure that the court may deem necessary to advance the right of privacy, including anonymity, taking into account the best interest of the child witness and right of the accused. Now, the last clause, over to Monika ji.
Thank you, sir. So this is the last guideline, which is clause 38, dealing with the standard operating procedure to be followed during virtual examination of a child witness. It provides judges shall ensure that the standard operating procedures affirmed by Honorable Supreme Court of India in re children in street situation is adhered to in all criminal trials where child witness does not reside near the court where trial is conducted and where child witness is examined virtually, not physically, by the court in which trial is conducted. These are the guidelines issued by Honorable Supreme Court of India, where it has been mentioned that the testimony of children who are victim of interstate, inter-district child trafficking is recorded through video conferencing, either at video conferencing room or of the court complex in the district, or vulnerable witness room in the court complex of the district, or the office of DLSA in the district where the child is residing. The guidance SOP of Honorable Supreme Court further provides that the Secretary DLSA of the district can be requested to be a remote point coordinator, or if the Chairman DLSA considers necessary, he or she may appoint a retired judicial officer as a remote point coordinator. So with this, we come to an end of all the guidelines which have been issued by Honorable High Court with regard to recording of evidence of vulnerable witnesses. We request the officers, if you have any query, please write in the box which is available on the screen. Or you can send your query on email on the address of Chandigarh Judicial Academy.